Most people think a jury decides what their injury case is worth. In Maryland, that's not always the case. Cases are resolved behind closed doors, long before a jury hears a word. And if you don't understand why that happens or how to use it to your advantage, you risk settling for far less than you should. This video breaks down the legal traps, timelines, and venue rules that quietly shape your leverage from the first day of your accident. So you stop negotiating in the dark and start building a case that settles for what it's actually worth. Hi, I'm attorney Bobby Zirkin. I've been an attorney for close to 30 years and was a member of the Maryland State Senate, Maryland House of Delegates. It's a simple fact that most Maryland injury cases don't even end up in a courtroom, but at a conference table through negotiation or mediation. That is not because trials are bad, it's because trials are slow, expensive, take a long time, and they're risky for both sides. The first thing to consider is where your case is filed. Maryland has two trial court systems. You have the district court, which handles cases up to $30,000 and uses a judge rather than a jury. And then you have the circuit court, which handles larger cases and is where jury trials occur. The amount you claim influences where we file, how the case proceeds, and a number of other factors. If the amount in controversy does not exceed $25,000, the plaintiff can try to get a jury trial, but it is typically handled in the district court. If a party is entitled to a jury and makes a jury trial demand, that case is then moved to the circuit court. Those rules shape strategy from day one because they affect discovery, timelines, leverage, cost, and so on. Deadlines that quietly decide outcomes. Maryland's general statute of limitations for personal injury is 3 years, generally, from the date that the claim accrues or the accident occurs. Miss that deadline, and the court will not hear your case, no matter how strong the facts are. There are exceptions for certain types of claims in special situations, but the safe rule is to always move early. Preserving evidence, capturing witness memories, and getting medical documentation aligned well before the deadline gives you options rather than excuses. The single biggest trial driver, liability. If the other side believes they can convince a judge or jury that you share fault, they are more likely to force a trial. Maryland follows the rule of contributory negligence. That means that if a judge or jury finds you even slightly at fault, you recover nothing in Maryland. We're only one of 3 states that has this rule. In 2013, Maryland's highest court reaffirmed that rule in a case called Coleman v. Soccer Association of Columbia, declining to replace it with what's called comparative negligence. It's up to the General Assembly to fix this issue. Because contributory negligence is a complete bar to recovery, insurance and insurers lean on it very hard. Our response is to investigate every case thoroughly, lock down favorable facts, anticipate every defense that the insurance company will make about your conduct. That preparation often makes the difference between a fair settlement and a courtroom battle. A narrow lifeline if fault is disputed. There is a doctrine called last clear chance. It's another one. In limited situations, it allows a plaintiff who was negligent earlier to recover if the defendant had a fresh opportunity or the last clear chance to avoid the harm and failed to take it. Maryland courts have recognized this narrow path for decades, including in cases like Thursby v. O'Rourke, decided all the way back in 1942. We do not rely on this doctrine to rescue a weak case. We use it to strengthen a strong one when the facts show that the defendant still could have prevented the injury after your momentary mistake. Damages, proof, and why medical records matter. Even when liability is clear, the defense may dispute the seriousness of your injuries or whether all of your treatment is related. That is why consistent medical care and clear documentation matter in every case. We work with your providers to tell the medical story in plain language so that the jury can understand it. Juries listen for credibility. So do claims adjusters. Maryland also caps non-economic damages such as pain and suffering. The cap is set by statute. It increases by $15,000 every year on October 1st, with the applicable cap tied to the date of the injury, not the date of the trial. Understanding that framework helps us value the case realistically and explain to you why an offer is or is not in range. Policy limits and practical leverage. Another quiet force that pushes cases towards settlements is insurance policy limit. If your losses clearly exceed the defendant's coverage, the insurer faces serious risk at trial. Well-documented damages plus clear liability can put the carrier in a little bit of a box. In those situations, the threat of a bad verdict works for you. When liability is contested or damages are modest, the insurer may be more willing to roll the dice and go to court. Our evaluation blends facts, medicine, venue, policy information, so you are never guessing why a negotiation is stuck. The litigation path that nudges cases to resolution. Once suit is filed, several steps increase settlement pressure. Written discovery forces both sides to show their cards. Depositions test credibility of witnesses. Independent medical examinations and defense experts reveal the other side's trial themes. Maryland courts also encourage alternative dispute resolution. Under the Maryland rules, courts can and will refer civil cases to mediation and or a settlement conference before the court, and the district court runs active day of trial mediation programs, meaning you go into court and they try to mediate it right there. These steps are not formalities. They are designed to help the parties resolve the case before trial. When we walk into mediation prepared for trial, the other side feels that pressure and negotiations usually get more serious. When trial becomes the best option, there are real situations where a Maryland injury case should be tried. The defense denies responsibility despite strong facts. The offer ignores the medical evidence. The insurer misreads a critical witness or underestimates how a jury might view your story. Sometimes the amount offered is far below what similar cases have produced in the same venue. When those conditions show up, trial is not a threat, it is our plan. We prepare you for testimony, we file focused motions to narrow what the jury should hear, and we select a jury that will listen with care. And we prepare for the jury trial. What a Maryland trial actually looks like. In district court, your case is tried before a judge who will decide both liability and damages. The process is more streamlined and moves more quickly. In circuit court, a jury is selected and hears opening statements, testimony from lay witnesses and medical experts, and closing arguments before deliberating on a verdict. Evidence rules are different in the district and the circuit courts. In the circuit court, exhibits must be authenticated, expert opinions must meet reliability standards. If the amount in controversy is above $25,000 and a party demands a jury, the case belongs in circuit court. Knowing these procedures lets us build the case for the room we are actually in rather than one that we hope to be in or was imagined. Timeline, cost, and the real odds. A contested case in circuit court can take a year or even more to reach trial. Discovery, motions practice, expert scheduling, and court calendars all take time. That delay is another reason many cases resolve at mediation or a pretrial settlement conference. Costs also grow with litigation. Expert fees, depositions, and trial exhibits are investments we make very carefully. You do not win a case by cutting corners, and you also do not help a client by spending money that does not move the needle. The goal is value and to get the best value for your case. The path to value is thoughtful pressure, not noise. How to help your case. Be consistent with medical care. Tell your providers everything, even small changes. Save receipts and keep a journal of symptoms, missed work, and daily limitations. Do not post about the incident or your injuries on social media. That never works out right. Share your pre-existing conditions with your lawyer so we can separate old problems from new harm and do it with honesty and clarity. Return calls quickly and review draft statements or affidavits with care. Jurors and adjusters reward clarity, consistency, and honesty. The more we can prove with records rather than argument, the stronger your settlement position becomes. Bottom line, will your Maryland injury case go to trial? Statistically, probably not, but could it? Absolutely. And we prepare every case as if it will go to trial. The courthouse rules on where a case is filed and when a jury is available, the 3-year filing deadline, the issues like contributory negligence or assumption of the risk, the narrow last clear chance doctrine, caps on non-economic damages, and lots of other issues feed into settlement value and trial risk. Use the system rather than letting it use you. That means early investigation, disciplined medical proof, and a willingness to try the case when the defense refuses to deal in good faith. Here's how we will proceed from here. We document liability with photos, witness statements, and any available video. We stabilize the medical story through treating providers rather than hired guns. We value the case within the Maryland framework so you understand the target before we ever talk numbers with the insurer. We choose the right court, and we keep pressure on with discovery, depositions, and mediation. When the defense bargains in good faith, we'll settle. When they don't, we will try the case. Now you understand how Maryland injury cases move through the system, from negotiation tables to courtrooms, and what drives those decisions. But there's one type of injury case in Maryland that follows completely different rules and creates unique opportunities for recovery: dog bite cases. Dog bite cases operate under their own legal framework in Maryland. Some cases have strict liability standards, others negligence. The valuation process is different depending on who we're suing and how strong of a case. The insurance coverage is different, with automobile accidents using auto insurance, and dog bite insurance usually comes from either homeowners or renters policies, or the landlord in some cases may be at fault. The strategies we use are tailored specifically to these different situations. In my next video, How to Value Dog Bite Cases in Maryland, I'll break down the specific laws that protect dog bite victims, how homeowners insurance or renters insurance comes into play, what factors drive settlement values higher or lower, and why these cases often resolve more favorably than other injury claims. Click on the next video, and I will see you over there.